How would you feel if you had to make a choice between buying food or spending your fixed income on life-saving medicine? No one should make that trade-off, but many low-income seniors are forced into difficult decisions like this every day. Smiles for Seniors Foundation provides energy assistance and safety net services to struggling low-income seniors in the Inland Empire. They provide one-time assistance to seniors to meet specific financial needs. They've helped with food, housing, utility payments, minor home and auto repairs, along with life-saving prescriptions or medical equipment. A nonprofit foundation funded entirely by donations from local organizations. Smiles for Seniors receives no funding from the state or federal government. They are funded by local businesses and individuals like you with big hearts and willing wallets. You can find more information or to donate to Smile for Seniors at 909-790-6671. That's 909-790-6671, or visit smilesforseniorsfoundation.org. That's smilesforseniorsfoundation.org.
Wishing for a little bit more information? You'll get it all here on KCAA Radio.
And now, it's For the People with Judge Herb Dodell.
Well, good afternoon, ladies and gentlemen. You know, one of the purposes of having the show, other than to help the people understand what it's really all about in the legal system and how it works from the inside, I like to every now and again just give an informational show, just to kind of help people understand what's going on in the real world in a more layman's address than by reading a technical book about it. So today I'm going to talk about the Constitution.
Great.
Because everybody's been talking about the Constitution.
Actually, there was a Supreme Court decision today.
Really? What was it?
They're about Planned Parenthood, and basically the Supreme Court ruled in their favor of Planned Parenthood. They didn't want to. They're not going to take the case of where states want to regulate Planned Parenthood and stop them from getting Medicaid. And state money for Medicaid.
So they declined to hear the case.
They declined to hear the case,
which leaves it with the circuit court opinion.
Exactly.
That's what now the law is at the circuit court level.
It goes back down there to the ruling.
Right. Usually these are things called writs of certiorari. It's not like Tipperary. It's like certiorari.
Yeah, they said they
don't
just
have to
didn't want
take
to hear
it if they don't want to hear it. They don't have to.
Yeah, and Brett Kavanaugh and John Roberts voted against it. Two conservative judges voted against hearing the case. So that's pretty interesting.
Well, it's going to be very interesting now because I'm going to talk about it during the show today. The reality is most people talk about like the Second Amendment. People just say it's the Second Amendment, but they don't know what the Second Amendment is. Oh, it's a right to have a gun and ammunition.
The bear arms.
Arm bears.
I have my bear arms every now and then.
Or you can arm bears. It depends on how you read it. I once saw a
that would be cool.
Saw a typographical error. It said arming bears.
Wouldn't it be cool to see an armed bear shoot a hunter? I think that'd be great.
Sounds like a great idea for a movie, Gary.
Let's write it.
Who can you get? Who can you get to play the major roles?
Vince Vaughn as the bear. I don't know.
Well, that's interesting. But first, I want to talk. I actually brought the actual section because I want to read it. It's very short.
The actual amendment to the Constitution.
This is the Second Amendment to the Constitution. By the way, the Constitution was written in 1789, obviously after the Declaration of Independence, but it was predicated mainly on things that were trying to address that they felt was unacceptable in terms of British rule, the way things were being done in England. They had developed a code of the law for centuries in England, not so in other places, but English law was pretty much the standard. And so there were a lot of abuses in England.
And they're still going on. I mean, the War of 1812, I mean, there was still British rule. I mean, even though we had the Declaration of Independence, there was a lot of influence still from Britain at that time. And they were still trying to take over America.
Well, that went on for a long time.
No, I know. I'm just saying.
The fact of the matter is, at that time, boy, you're so knowledgeable. At that time,
it wasn't like I was there, Judge, or maybe I was.
Well, maybe you were. I could see it with one of those big hats, you know. like the three-cornered hat.
I was
standing on. I was going to say sitting in the little rowboat, with a little thing, a little microphone, not a microphone, a little what do they call those things?
And then another hit of opium, please. It's cold out here.
You could have been good at Valley Forge.
I might have,
but it says a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed.
So break that down for us. What the hell does that mean?
There were many arguments about what that means, because it says, talks about a militia. I didn't think much about the militia thing for a long time, until recently. Now that you can see what's going on in the headlines, really, and you can see some of the infringements that are taking place little by little. The fear is that at some point in time, just as it happened in Nazi Germany, the government could become autocratic, and it could be taken over by some elements. I'm not saying that's going to happen. I
don't see that happening, Judge.
I don't see it happening either, but I was telling somebody the other day, when I look at things, I have to look at worst case scenarios. As a lawyer, you always look at the worst case scenario. What are you looking at? What can you do about it if it happens? And so he said, well, look, in Germany, in Weimar, Germany, Weimar was between the First and Second World Wars. In Weimar, Germany, there was a major democracy. There was pretty much everybody was free to do what they wanted to do until Hitler took over. And then you would think that all of these people, intelligent people, educated people, would resist what happened. But they didn't resist. In fact, the army took instructions from the boss. Whatever those instructions were, they did it. There was no thinking about it or anything else. And so a well-regulated militia, if you will, of the people might have made a difference. Probably not under the circumstances, historical circumstances, but it's possible that if there had been an opposition, an armed opposition, might have been able to overthrow even the elected democratic government that the people elected. And so that's always a possibility. And I think that the NRA, I don't know much about their internal workings, but their argument is we want to be able to have our own weapons to protect ourselves in case the government takes over.
Yeah, I mean,
a lot. If you look at it, if you look at the literal terms, one could make that argument.
Yeah, but you know what? I mean, yeah, everybody should have the right to bear arms. Okay, I get that. People like me do not want to take away people's right to own arms or guns. I just don't think you need to own a semi-automatic weapon or an automatic weapon. What are you going to do with that? The only thing that's a killing machine of humanity. Okay, that's all. You're not going to go out there and you're not going to go out there and shoot a deer with an automatic weapon unless you're a complete maniac. Okay, you're not going to use it for anything but killing human beings. And I'd like to debate you on this, because before the show we were talking about this, and I said, would the founding fathers probably change the Second Amendment? And you said no. I think they would.
Well, there hadn't been any real case law on the subject until 2008, when the case of District of Columbia versus Heller was decided. That case by the United States Supreme Court pretty much said the individual has a right to pretty much use whatever they want, whenever they want it. And the purpose of it is to defend yourself. And what they did, and it's interesting because I read you the section, it's only like maybe 20 words. They said the first part, which is a well-regulated militia, does not limit or expand the latter part of the sentence, which says the right of the people to keep and bear arms shall not be infringed. And so they're saying, let's just emphasize the second part of that. That has nothing to do with the militia. It has the right to the people to do whatever it was. That was an opinion that was decided by the Supreme Court, as I mentioned. And it was followed by another case called McDonald versus Chicago, where they also set aside a law that required people to register and do a whole variety of other things. And they set that one aside also. So it'll be interesting now when you talked about the Supreme Court composition today, and you're talking about Kavanaugh and you're talking about Gorsuch. The conservatives, may just very well say, called the strict constructionists, that's what they're called. Strict constructionists might say, look, the amendment says militia. There's no militia involved. Therefore, people cannot have it unless they're forming a militia. And a militia applies to the states through what's called the 14th Amendment, which says federal law applies to the states as well. So even the states can't regulate against people having guns or ammunition. So in response to your AK-47...
Go ahead.
I'll wake you up for that one. For the AK-47, if you follow the logic of it about militias, and you want to make sure that the people can be in equal position with the government so they could defend themselves.
Oh, yeah.
Then if the government's got AK-47s, then the people should have them too.
Okay, you know
I'm just giving you a logical argument.
I dig it.
I'm not saying I agree.
I hear you, brother.
First of all, I don't agree with the first part. I think you were looking at them in 1789. Militias were different then.
Please.
Today, I think everybody's got the right to have a gun, unless they shouldn't have a gun.
Well, let's talk about what kind of gun they should have. I think everybody should be able to own a gun too, but what kind of gun? That's the problem.
No, it should be limited to muskets.
I wish they would. All right, we got to take a break. We'll be back after this with the judge.
50 a.m. KCAA.
Herb Dodell is a lawyer and a judge for the people. Having served as a Superior Court judge, presiding over more than 9,000 cases, he has witnessed firsthand how complicated and corrupt the legal system can be. His goal is to show how things really work in the legal system so that people can navigate the legal system in the best way for them. Many people often feel marginalized by the legal system and are uninformed about how to proceed when unfortunate circumstances arise in their life. Judge Herb will pull back the curtain, lift the veil, so people can truly understand their rights, have access to top legal personnel that they can trust, and have knowledge about how things work so they can make better choices. Judge Herb isn't just knowledgeable. His integrity and spiritual values are truly what make him different. He cares about democratizing access and information for all and desires to turn on the light so the people, you, can benefit. For more information, email the judge at askjudgeherb@gmail.com. That's askjudgeherb@gmail.com.
We're back with guns drawn. The fact of the matter is, it's such a broad subject that would take a long time.
You can talk about it for hours and hours.
You could go on. Look, the people at the NRA are very, very serious about their position.
Can I just say one thing?
They don't move.
Can I just say one thing? This year, 2018.
98.
What?
You're going to say 98 schools.
94. 94 school shootings here in America, the highest by 60%. The highest since 1970. 94 school shootings. We're not counting borderline. We're not talking about the massacre at the synagogue. We're not talking about the Pulse nightclub. We're not talking about the church. We're talking about schools. I mean, Judge, I don't know. I have a very strong feeling about this whole. Like I said, I don't want to take away people's rights to own a gun, but I just don't understand the automatic weapon thing. Because these guys are going in there using these automatic weapons every time and blowing people away for absolutely zero reason except for there's something wrong with them mentally or whatever it may be.
Well, you know the proposal that I made to limit gun ownership or ammunition ownership.
And I think it's a great idea. Too bad your friend from the Senate doesn't do anything about it.
Well, he really can't. You know, he's in the minority. And the fact of the matter is I get great responses from everybody that I talk to about the idea, which, by the way, will make it real clear for those who have not heard it before. I want to set up a national database of all restraining orders because I was assigned to restraining orders for about 6 years. And there has to be a national database because whenever we grant a restraining order, there's an order that requires them to turn over their guns or sell it to a legitimate seller and certify within 48 hours that they've done that. That's the rule. That's the law. So we already have a law on the books. And it means that some neutral judge has decided that person is either unstable or is a high risk, credible risk, and things for continuing misconduct or whatever. You get a database. Now somebody selling a gun has to read the database. If the database shows the name of the person on there without anything further, they have to call law enforcement. They don't sell the gun, obviously, but they call law enforcement. Why? Because it's a court order. Well, when we sign a court order, that's the law applicable to that particular situation. And so now they call law enforcement, and it could be a teenager. It could be somebody that it's a high risk who's made statements. And with the proliferation of social media today, people say all kinds of things that you never figure anybody in their right mind would say, but they do it anyway.
Yeah.
And so you've now got a little red light that's gone on that there's somebody out there that's trying to get a gun that shouldn't have one. Why are they doing that? Especially if you're looking at the grade of gun they're trying to buy. If they're looking to buy a .22 or a deer hunting rifle or whatever it is, that's one thing.
Right.
But if they're out there looking to get weapons of mass destruction,
yes,
that's another story
exactly.
altogether.
That's what I'm saying.
And if somebody sells a gun to somebody who's on that database, and that person uses a gun and commits a crime with it, even murder, there's a concept in the law, it's called the felony murder rule. That means even if you're not pulling the trigger, if you're not even in the room, you could be equally responsible as the person who actually pulled the trigger. That's the felony murder rule.
Or at least be civil liable.
Well, they'd be civilly liable anyway, without going into the details of whether it would be a negligence case or something else.
Okay.
The fact of the matter is, gun control is a major issue, and that's why I chose today to talk about the Second Amendment, because it's so popular. So now I want to move on to the First Amendment, going backwards.
That's freedom of speech?
Here it is, First Amendment. I'm going to read it again.
I've been dealing with that.
Well, I think now it's even more prominent. You know why? Because of social media. People are saying all kinds of things about other people. And it's people trying to sell you with a program that they'll take it off and they'll eliminate all of the bad credit reports. I mean, that's nonsense. Once it's in there, it's in there. It's even like restraining orders. Once we sign even a temporary restraining order, and you've heard me rail about that, I think that's a disgrace that we insist that even temporary restraining orders, if they're not granted later on a permanent basis, are still usable. Still part of the public record, part of what they call the CLED system. And so the fact of the matter is today, you could ruin somebody's life with a tweet.
Exactly.
Or you say something stupid and somebody publishes it or reposts it or whatever they call that. And the bottom line is it's out there viral. Your life's changed.
Look what happened to Kevin Hart. He was going to host the Oscars.
Well, he's not hosting them anymore.
Exactly, because of his tweets.
I don't know what he said.
Yeah, they dug up a bunch of homophobic tweets that he did like 10 years ago. And basically, they kicked him off the Oscars, or he declined or whatever.
Well,
stepped down.
You look at all the people who lost their jobs for the alleged sexual allegations, some of which probably have no real merit. Some do and some don't. Everybody's got their own motivation. But you know what happened? You get accused of that, game is over. It's not like you have to prove that you're innocent. You are guilty because in the public eye, you're guilty.
That's why I don't do any social media. I don't say a damn word to anything about anybody.
You said damn. You used to not be able to say that.
Well, they might cut it out.
You can say that now. Well, you were prohibited from using the word hell or things like that. Those days we were a little more conservative about it, as a matter of fact. But the First Amendment says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or the right of the people peaceably to assemble and to petition the government for a redress of grievances. Now, that's your free speech.
What the hell does that mean?
It means pretty much...
Sorry, I used hell.
No, it pretty much means you can say almost everything you want to say. However, when I was doing restraining order cases, a lot of them were arguments that people were making threats. Well, threats are free speech. Isn't that really?
But you're harm. But you're when you threaten somebody, you like to harm. Yeah, well, intent to do harm.
What you end up with is a balancing act between the right to say whatever you want to say. For example, you can teach people in making public speeches that the use of violence is an acceptable way to make change. You can say that. That's free speech, especially when you're talking to crowds of people or more than one. On the other hand, you can't say to incite somebody to go out and kill particular people. You can't do that.
Well, wasn't there a famous case recently that a girl, this guy was thinking about committing suicide, and she said, well, go ahead and do it, and something like that, and he killed himself, and I think she got arrested for it and went to trial. I don't remember what the verdict was.
I think the verdict was in her favor.
Yeah, I don't remember that. But I mean, she got arrested for saying, well, hey, if you want to kill yourself, kill yourself.
I'm sure it became a free speech issue at that trial.
Exactly.
Look, there's a case called Brekke, Brekke, in California. I mentioned it on the show before, where a 15-year-old boy was writing to his 16-year-old girlfriend and telling her that he was planning on killing her parents. And obviously, he was ultimately involved in a restraining order case. And his argument was, it's free speech. She wasn't, nobody was going to take me seriously or whatever it was that he was saying. And the court said, no, that a reasonable person could feel fear for their lives based on that kind of statement. It was like that. I've told this story probably 3 or 4 times. The case that I had in restraining order court where there was a lady came in with her cell phone, and she showed me that on the cell phone was a text with the picture, the whole deal, of a lady sitting on the floor with a beer bottle in one hand and a gun in the other with a caption underneath, "You're next," or something like that. Well, obviously, I granted the restraining order, but that's free speech too. Everything is free speech.
So where's the line?
The line it's interesting that going back to the U.S. Supreme Court, it's probably been 60 years since the decision has been made. It was Neer versus Minnesota was the case. And Justice Oliver Wendell Holmes said, free speech does not give you the right, I'm paraphrasing, does not give you the right to yell fire in a crowded theater. And so you have to balance whether it's really truly free speech or not, or if it's threatening. And so today, the same thing. They're keeping certain contents off of the social media that they perceive are beyond free speech. We'll leave out the freedom of religion. That usually is pretty simple. The right to assembly, that was to allow people to object. What's really interesting is I was listening in the car on the way down. The French passed this resolution or passed this law that was going to increase the gasoline taxes.
They're freaking out.
They freaked out. And the government backed off because there were mobs, literally mobs, people wearing yellow jackets, objecting. Well, that's the right to assemble. And so there are some regulations about that too. Does that mean you can just tomorrow morning on your own with telling nobody round up 100 people and march in front of some place? No, because the government has the right to regulate activities of the public. And so you might need a permit.
Right.
But should they deny your permit? Generally, they don't deny the
Well, look what happened in Charleston. I mean, that whole white supremacist rally in Charleston over the statue, and they got a permit to do their thing and spew their hatred, and then they had a big, fight with the other side, and, so, I mean, that's freedom of speech, even though, it's spewing hatred towards other people.
But freedom of speech is very important because that's how you convince people
but works both ways.
Might be both ways in what way?
Well, I mean, you got people that are spewing this hatred out there, and they're actually and it's taking a whole new dimension now in America.
Yes, it has. The last couple of years have been more volatile than it's been in a long, long time.
Exactly. So you're allowing this.
But they're coming out. But those are the people. Those people believed what they believed. They might have been a threat in other ways. Now they feel that they have the ability to go out and say so. And, I don't agree with what they say, but they got the right to say it.
I dig it, but that's the point.
But but I was also thinking, there are websites that are strictly hate websites.
Yes.
They're out there, they're running. People are going on those websites and they're looking at the information. The Nazis got their own website. They don't get along with the communists, but everybody's got their own group of people, and they're saying whatever they want to say. And that's what makes the country great, the ability to say what you believe, as long as you're not inspiring people to do things to hurt others.
Well, I mean, by spewing hate, talking about hate and spewing hate, I think you are hurting other people. And I think that's why we're having such a backlash and why we're such a divided country. I think there should be some sort of regulation.
Well,
personally,
the whole thing is in flux right now because there are people on both sides, the liberals on one side, the conservatives on the other.
Yeah, they're both idiots.
And, well,
they are.
You can prove historically that it's the fringes, the ones that are at the far, far end, right and left, that are the problem. So we'll talk about the next amendment right after the break.
All right, it's for the people of Judge Herb Dodell. If you want to ask the judge a question, you can email him, askjudgeherb@gmail.com, and get his book, From the Trench to the Bench. It's a great stocking stuffer. It's available on Amazon.
Have a very big stuffing.
Well, whatever.
Very big stocking.
Stocking.
Stocking. But that's about stalking.
Your friend over here has some nice stockings. All right, we got to take a break. We'll be back.
NBC Talk Radio, 1050 AM, KCAA.
In his book, From the Trench to the Bench, Judge Herb Dodell demystifies the legal system, including both civil and criminal, the lawyers, the judges, and the process. As a judge, former deputy district attorney, and criminal defense attorney, he knows the legal system. He has the inside information that you need to pick a lawyer, and he's here to give it to you. No matter what you're facing that makes you think you may need a lawyer, Judge Herb will shed valuable light on your situation and reveal your best options and many secrets of how the judicial system actually works. To find out more about how the legal system really works, you can get your copy of Judge Herb Dodell's eye-opening book, From the Trench to the Bench, at Amazon.com.
Okay, actually, I picked 4 amendments today to talk about, figuring.
For people that don't know, how many amendments do they have to the Constitution?
I think it's 26. I'm not
26?
Sure. Yeah.
I thought it was like 15.
No.
Is that the Bill of Rights?
The Bill of Rights is basically the first 10 amendments
of the Constitution.
But the 14th Amendment, which was basically making it all applicable to the states, there wasn't a lot of action thereafter for a long time. But lately there have been some amendments. The last one, I think, not sure, was the one on how to remove a president. That's the one.
Interesting.
Well, don't get too happy about that because it ain't going to ever happen.
You don't think?
Not using this process. This process requires half of the cabinet and the vice president to recommend to the Senate that the president is incompetent or incapable of work. I think it came about as a result of a president having a stroke or being shot. It might have been even Reagan being shot.
No, it goes back to, I think, Woodrow Wilson when he was sick. I think that's when it goes back to. Was
Woody sick?
Yeah, Woodrow Wilson was very sick, and basically his wife was almost running the country. From what I read back, I'm sort of a history cat. But yeah, it was. I think it goes back to that.
The shot that Melania is going to run the place?
Well, she could decorate it in all gold. Let's make it all gold. Yeah.
Anyway, I want to talk about the next amendment. I want to talk about is the 4th Amendment, and don't ask me what the 3rd Amendment is.
Come on!
I don't remember. Actually,
my favorite number is 3. Tell me what it is.
Well, I'm going to tell you what the 4th is. That's the Search and Seizure Amendment.
Oh, really?
That's warrants.
Warrants?
Yeah, and how to get a warrant?
I think you have to go through a court.
You do.
Wow, I guessed that one.
You absolutely do. In fact, there's that special court, the FIFA court.
Yeah, Pfizer court.
Pfizer court that deals with, it's in the federal system.
What's the difference between it? What's a Pfizer court? Tell us for people who don't know.
Well, that's to really to, I suppose, deal with the issues of privacy and overstepping the need for the warrants, you have to make certain accusations and allegations and support those allegations.
Is that state or federal?
That's federal.
Okay, so did they get a Pfizer warrant for Manafort or Michael Cohen? Do you know?
I don't think they got one for Michael Cohen.
Yeah, because that was a state thing, right?
Most of it was, but I'm not sure of all the particular charges. But the fact of the matter is, I remember there was a judge in Beverly Hills. She's been gone a while, and she was not exactly the brightest bulb in the array. But she would sign any you see, what happens is the DA, like when I was a DA, you'd go into the judge, and you'd see you want a search warrant or an arrest warrant, generally a search warrant. The arrest warrant is, they're out there someplace, you just want to serve them with a piece of paper and take them in with handcuffs. But search warrants are very, very different, and were abused horribly, really horribly abused. And it basically requires the court to find what's called probable cause, that there's a reasonable basis. Now, a lot of that had to do, the FISA courts had a lot to do with wiretapping. And it had a lot to do with surveillance.
Like secretive stuff.
Yeah, sure. Look, they make cases by grabbing people's computers these days. What's in there is convicting people all the time because many people are too stupid to recognize. Don't put it down. I had an old mafia client who said to me, "You don't want it known, don't say it on the phone." Or tweet it. And he would not. This guy would never talk to me on the phone. If he had something to say, he'd come down to my office. He wouldn't even talk to me in my office. He'd say, "Let's go for a walk." And
that's smart.
I would walk on Sunset Boulevard with him, and that's when he would talk to me. He was afraid the office was bugged, and he didn't want anybody to have any written documents or anything like that. So getting a warrant should be hard. I shouldn't say hard. It should be enough to satisfy a reasonable person that there's a justifiable basis for it. But she signed everything. It didn't make any difference what it was. Stuck it in front of her, she signed it.
Wow.
And those judges exist in more than just one place. It's the same thing I told you in the beginning when we started talking about restraining orders. There are judges who sign temporary restraining orders just almost automatically.
I mean, they don't even look at the case or, have any thought process on it?
Well, the problem with temporary restraining orders is it's one-sided. And what happens is somebody just makes up a story as they go, files a document called a petition, and seeking this relief, and you're looking at it in chambers. You don't see anybody. I think I told you, of all the years that I was sitting in restraining orders and was reading a lot of these applications or petitions, I only came out twice. Once was a celebrity. I wanted to see who she really was. So
was she hot?
She was looking for restraining order. I came out. She was there with her husband. Oh, yeah. That one, and I came out another one for a disc jockey. Lady disc jockey.
Okay.
But for the most part, you read them in chambers, and if it looks like it's serious, you sign it. You don't really know how good or bad it is. And I would argue with this other judge all the time. I say, you know what? Some of this is such junk. You know it's junk. Why do you want to ruin somebody's life by making a permanent record out of it?
I mean, yeah,
he would
exactly.
He would sign 85%. If I signed, you have to kind of be careful.
How many did you sign, Judge? Percentage?
Not a lot of temporary.
30, 40?
I signed more temporary restraining orders than I signed permanent ones. Permanent ones, I once asked my clerk. She wasn't exactly keeping track, but she pretty much knew how many we were seeing every day. And she said, I granted about 5% of the permanent restraining orders.
Right.
The temporaries, you have to say to yourself, if what they're saying is true, if it qualifies.
Let me ask this question. Okay, so a temporary restraining order, then you get a temporary restraining order, and then you go to court for a permanent restraining order?
Yeah, 21 days later, within 21 days.
Okay, so that's what my ex-wife did, basically.
We talked about that.
I know. I'm just
100 miles away.
I was 100 miles away.
You were in Laguna at a bar.
Exactly, getting loaded.
I'm sure that did a lot for your credibility on your application.
I didn't put down getting loaded. I just showed.
But I want to get back to warrants. I want to get back to warrants. Now, there's a concept that people hear all the time on all of these lawyer shows. it's called a fruit of the poisonous tree. Heard that expression before?
Of course I have.
You know what it means?
I do, but go ahead and explain it.
It means that if you make what's called a 1538.5 motion,
I don't know
California,
about that, but
that's what it's called in California. Well,
Okay.
you should. Your father was a criminal lawyer.
I know. I mean, I don't know that.
1538.5 is
that-
basically an attack on the warrant.
Okay.
That there was insufficient probable cause for the warrant to have been granted, and therefore, if the warrant is set aside or quashed, that means that anything that was obtained as a result of that warrant is not usable.
Right.
I told the story before. I had this major criminal case many, many years ago, and it was a grand theft of several $1 million from some gold vaults that were down in Orange County. And they had made a deal with the depositors that if the depositor wanted their gold back, they could get it back within 24 hours. In the meantime, the client, the owner of the company, could use that as collateral and whatever it was, and they were paying interest on it. So once they were busted, the two of them, my client and his employee, they went to the car, one of them's cars, and opened the trunk and found a document inside the trunk that said, Christmas came early. One of the customers' name was Christmas, Helene Christmas. And so one guy was writing to the other guy saying, she didn't give us enough notice. All of a sudden, we got to give her all this gold. We don't have it. And that was the argument. It was that he basically staged a robbery that never really took place in order to say, well, they came in with guns and they took all the gold after he'd already spent it, that kind of thing.
Yeah.
Well, I made a motion to suppress. That's what it's called, a motion to suppress. And I made that motion on the basis that they didn't have a warrant to go into the trunk of his car. There are exceptions to the warrant rules. In other words, if it's exigent circumstances, it might apply. If you've arrested somebody, you can search them incident to that arrest. There are exceptions to it. But I made the pitch, and he was a very good judge, a legit guy. And he granted my motion, and it kept the letter out. I could go on and on about.
So the rest of the stuff sort of went by the wayside.
Only the stuff that they got pursuant to an unlawful warrant. The stuff that they had otherwise. Well, they didn't have a search warrant.
Well, I'm saying,
if they have a search warrant, they're usually pretty broad. They want everything that you got, and they'll identify it.
So they didn't have a warrant when they went into the trunk.
Didn't have. Should have.
Okay, that's what I thought.
But sometimes they're in a hurry, and they'll go to somebody's house and say, "Will you let us in and search your house?" No, push them out of the way and go in and search the house.
Oh, you can't do that.
Can't do that.
Yeah.
Can't do that. You got to get a warrant.
Right.
So most of the time, they're about to make a bust somewhere. They get the warrant first, search warrant.
Yeah.
And then they search incident to the arrest. They go through everything and they catalog it and whatever. How do you think they got Cohen? He had written some emails or stuff. It was in his, whenever they seized his records, there it was. They now knew exactly what was going on. Whether it was ever quashed or not didn't really make any difference.
But how they get the search warrant? Yeah, what was the evidence? That's what I'm curious about. What was the evidence to get the search warrant to break into his apartment and his office at 6:30 in the morning?
They probably said that there was unlawful activity going on, and get some specifics that taxes weren't being paid or whatever it is.
They had some information, right?
Yeah, and you know what? What happens in real life?
Yeah, real life.
Is they get a search warrant for A, and they go in to do the search, and they find B.
Right.
B is okay. If they found that incident to the search.
How if you don't find A, though? How if you don't find A? Anything on A? Does it still count?
That's subject to a motion to suppress.
Okay, there you go.
I would think no. I think that if they had a warrant
for a certain thing
for criminal, well, if it wasn't so specific, if it was general enough, and that while they're looking in the drawers for A, they find a loaded gun or whatever it is.
They find B.
They find B. Whether they find A or not, I think it's probably admissible. Probably.
But that's something you could fight.
You could fight it. Granting of 1538.5 motions is not that frequent. I mean, I've won a bunch of them over the years. I really have. So surprisingly, and I was unsuccessful in defending someone. I was in the DA's office. Sometimes it's the facts are not there to support it. Yeah. And a lot of times they'll go in, law enforcement, and make it up as they go, hoping something's going to stick.
I never knew this about the Fourth Amendment.
That's the Fourth Amendment.
Wow, I didn't even know that.
Search and seizure.
Okay, cool.
So the last one
That you're talking about today.
Oh, yeah.
There's plenty of them.
Well, believe it or not, a lot of them don't seem to have much.
Yeah, but I like it. But to be interesting, since they wrote it into the Constitution, they must have thought they were important, but we don't really utilize them in today's society,
no, you
correct?
Don't. The Sixth Amendment provides for jury trials.
Oh, really? Okay, that's cool.
Why?
That's a good
Because they didn't have juries in England. They wanted to make sure that the public was represented.
That's very interesting.
A trial by your peers. That's the definition. I don't remember the exact language, and I didn't print it for today. But those are important, but nobody really challenges those. You have a right to a jury trial.
That's great.
There was challenged previously on the grounds that some of these juries were tainted. Either there was discrimination or whatever it was, and some of the arguments.
Like OJ?
You know what I think about the OJ trial.
I know. Well, I'm just saying that looked a little tainted to me.
Well,
there you go.
If they'd have tried that case in Santa Monica like they tried the civil case, he would have been convicted, in my opinion.
Absolutely. I agree with you. Let's take a break, huh?
Okay, we'll talk about the Fifth Amendment coming up.
Can't wait. No, I dig this. This is great information. All right, it's for the people, Judge Herb Dodell, and we'll be back with more from the judge right after this.
NBC Talk Radio, 1050 AM, KCAA.
Did you ever meet a lawyer that was for the people? Someone who had the best interests of the people at heart? Herb Dodell has been a lawyer for more than 50 years and has been a Superior Court judge for 9 years, having presided over more than 9,000 cases. In this show, he will reveal the secrets of how things really work in the legal system, so you can maximize your position and benefit most when you're in trouble and need someone on your side to simplify the process for you. For more information, email the judge at askjudgeherb@gmail.com. That's askjudgeherb@gmail.com.
Okay, so for today, we're going to deal with one more amendment, a very important amendment, and I left it for last for today because it's becoming discussed on a very regular basis, almost a daily basis.
Really? What is it?
It's called the Fifth Amendment.
Okay,
And what it says, and I wrote the little printout today, it says, no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia.
The militia again?
None of this really applies.
I don't understand it.
When in actual service in time of war or public danger. That's not the part that anybody pays attention to. Then it says, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. You've heard of that one.
Double jeopardy.
Right.
Oh.
Nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process, key words, due process, of law, nor shall private property be taken for public use without just compensation. That's eminent domain.
That's the Fifth Amendment?
That's the whole Fifth Amendment.
Wow.
The part that matters,
Yes.
nor shall be compelled in any criminal case to be a witness against himself. And
I plead the Fifth.
that goes a lot further than it sounds like on the paper alone. Many people have heard this name mentioned and have heard it mentioned since the case was decided. Probably, I think I was in law school when the case was decided. Miranda.
Yes, your Miranda rights.
Miranda rights. You know what Miranda rights are?
I do not. I sort of do, but I don't. I mean, I don't know the breakdown of it, but of course, it's sort of your freedom to not testify against yourself or incriminate yourself.
Actually, it goes further than that.
Okay, well, I'm just doing the.
Miranda got busted.
Not a judge.
And then, Miranda got busted, and they questioned him about the events and the circumstances and ultimately charged him with the crime. He didn't have a lawyer. He couldn't afford a lawyer. And so the argument was made successfully by Miranda's lawyers that he was basically testifying against himself, and there was no due process. Due process means you have to follow the rules.
Right.
And he was not given any information about what he was subjecting himself to. And so they said, unless these Miranda requirements are met, any confession, that's what it deals with, usually confessions, any confession gets thrown out.
Now, Miranda, was this back in the 1700s?
No, it was in the 1900s.
Okay, well, I'm just asking.
I may be old, but I'm not that old.
Well, I was asking
I
about
was
your
I was in law school at the time.
Well, we're talking about the Fifth Amendment, so I'm figuring.
Well, actually, the Fifth Amendment was written in 1789.
Right, but this isn't included. This isn't a part of a
It's part of the Constitution.
Right, that's what I'm saying. So what's it called? A denim or whatever?
Amendment. But the argument was made, successfully made, that he should have been advised that he had a right to a lawyer.
Okay.
Because the lawyers, if they got any sense at all, he or she's not going to let them confess.
Of course
Usually not. There's deal making, and the client is usually not in the room. The lawyers are talking about what kind of deal they can make. It's all about Monty Hall. You can get 5 years here or 2 years here, and you trade it off. And then the lawyer says, what if he was going to say such and such? That's what he's going to say.
Of course, plea bargain.
And so you're entitled to a lawyer. You don't have a lawyer and you ask for one, nothing you say is going to be usable. If you start talking on your own and you don't ask for a lawyer, that part may be admissible. Maybe. But once you ask for the lawyer, no matter where you are in the conversation, they got to stop right there, and that's when you get the lawyer. And if you can't afford a lawyer, they make sure that one is appointed for you.
Public defender.
There's a financial form that everybody fills out that they're looking for the services of the PD, public defender. And so if you qualify, and the rules are, I guess they're somewhat flexible. And if you're making $75,000 a year, you're not qualifying for the PD. But if you're working at McDonald's and your expenses are greater than how much money you make, then you may. So the public defender were overwhelmed.
Yeah.
I remember when I was in the DA's office, they would come in with a stack of files, and they spent their morning in the lockup. They call it the lockup.
Yeah.
And they were interviewing people. There was just one after another, after another. And that's my only negative comment about the public defender's office. The only one is that they're so overwhelmed that they're dealing in a lot of cases that maybe they could have done better.
Yeah. Well,
and when you're a private client and you're paying somebody to do it, the motivation's a lot different. You'll go a lot further. I was telling somebody the other day about a sentencing. What I used to do when I was practicing full time is I would write a pre-plea probation report of my own. I wasn't waiting for the probation department to say they put the guy away for 20 years. I'd have that client interviewed by a psychologist or a medical doctor or something, whatever, and write one of these glowing letters that he was bad and he's sorry and whatever it is, contrite, etc. And the judge reads it. You sit in chambers and you read it. And while the probation department may be wishy-washy and your guy writes a better report, it works in sentencing. You may be able to get a home detention or a bracelet or something instead of going to the joint.
Yeah.
The joint is this state prison.
Right.
And so the bottom line is Miranda is very, very important. In fact, it applies to statements. It does not be confessions. It's anything that you say. And it says it can and will be used against you. And they do.
Well, I mean, when they arrest you, they give you your Miranda rights.
Well, they're supposed to, yes.
I mean, well, if they don't, then...
it's an amazing thing.
They have to, don't they?
A lot of the cops are still reading off the card.
Yeah, well, they have to give you your Miranda rights.
They have to, yes.
I mean, that's part... They don't...
And any crime.
Any crime.
No, all it really does is makes whatever you say inadmissible.
Oh, really? That's what...
If that's all they have. And you've heard the term corroboration.
Yeah.
A lot of times a statement isn't good enough on its own. Because a lot of times it's hearsay, it's circumstantial, it's not supported. Collaboration is what makes all the difference. That's how they're getting Manafort. They got corroboration from a lot of other witnesses. Same thing with Cohen. And they knew that. They knew that there was going to be other witnesses going to testify. And if they didn't make the deal now, that deal is going to be off the table. That's
Well,
the expression, by the way, off the table.
Yeah, I'll tell you, it's going to be interesting next year.
Can you take a Fifth Amendment in a civil case? Just thought I'd ask you that question.
I don't think you can.
Yes, you can.
Well, you're not. Well, you're not supposed to.
No, yes, you can.
Well, I mean, a lot. I mean, you can, but normally they don't.
No, yes, you do.
Really? I mean, why didn't OJ?
Why
didn't OJ take the Fifth Amendment? Why was OJ?
No, in the civil case, he has to testify.
Okay, but he can plead the Fifth, right?
He could plead the Fifth. Sure.
So why didn't he plead the Fifth on some of this stuff?
I don't know. There are statements that are being made by people today that if you take the Fifth, it means you're guilty.
Exactly.
I remember when I was first starting out doing criminal defense.
Right.
I was always very concerned about having my clients take the Fifth if they were. I would never raise it, and they can't force you to testify in a criminal case. Nobody knows about the Fifth because you don't get called. They can't call you. You can't, if you don't put them on or on, it never comes up. But I'm sure there was many times that in a civil case, in an arson case, by the way, it's a civil case, could be civil or criminal, or an insurance fraud case, civil or criminal. The fact of the matter is, if they take the client's deposition in a civil case, what do you think happens with that testimony? It's straight down to the district attorney's office. So you can take this. You can take the Fifth in a civil case if there is a possibility
that you could get criminally charged.
That you could be criminally charged. That's
Yeah.
exactly right. I mean, there are ramifications in the civil context of an insurance claim. The insurance company will deny the claim, and oftentimes will do that. And there's all kinds of ways of maneuvering around it. But I've heard oftentimes people say recently, coming from Washington, actually, the only people who take the Fifth are the mob. That's not so. In almost every case where there's a potential statement made by the other side, by the defendant, they're going to take the Fifth. I used to be concerned that the jury would conclude that because they took the Fifth, they were guilty.
Well, just like with Furman. I mean, he pleaded the Fifth, and because of the racist statements he said, and they assumed that he was guilty. This happens all the time. And especially and I think the difference in between civil and criminal, and this, of course, is that the guilt, the preponderance, opposed to the other in the criminal court beyond a reasonable doubt. I think that's why people maybe have a little different attitude.
Well, no, there's a jury instruction if you want to ask for it, that says that they should not imply anything from a witness's non-testifying. It was the same reason I wouldn't put the witnesses on the stand. If I put them on the stand, could end up being a waiver, depending on how far it went.
Yeah.
In fact, grand juries, lawyers don't go in. It's strictly the prosecutors and the subject, or the person who's subpoenaed. I was going to mention because we were talking about a lot of things dealing with prior cases. When I was first out, I was the lawyer for a movie called Deep Throat. Remember that movie? I was the lawyer for the.
No, I don't remember it, Judge.
You may have been too young.
Yeah, right.
Well, no, I was the lawyer for the distributor.
Oh, really?
The argument was that he was distributing pornography.
Well, wasn't
and they was dragged into the grand jury. And I stood outside. He would come out, and he'd go back in. I'd tell him, after your address, you say nothing.
Did you meet Linda Lovelace?
I did not.
Okay. Just ask.
I didn't meet anybody except the distributor. Okay. He was a greasy guy, actually. I kind of remember. He's probably been dead 40 years. But that was a case where he's basically taken the Fifth Amendment.
Yeah.
And it prevented him from getting indicted, although later on he was indicted anyway. And it made its way up through the appellate courts because that was one of the first cases that came along on whether or not they could regulate pornography.
Yeah.
And it goes back to a case, Griswold versus Connecticut. There was a whole bunch of cases that came along on that subject dealing with what's pornographic and is it a violation of free speech and free expression. And so the free expression won out. That's why you have pretty much unfettered use of the radio, television, or any other device to pretty much say whatever you want to say. It's got to be pretty bad to get dinged Child pornography, of course, is
that's
verboten everywhere.
Disgusting, yeah.
It's verboten everywhere, so that you don't even get into an issue of free speech or anything else.
Yeah.
But that's an extreme case. For the most part, pretty much everything goes. It reminds me of that great song, "Anything Goes." Yeah.
Baby, it's cold outside.
That's to me, that's pushing the envelope.
Oh yeah, right. I heard it today for the first time. Yeah, that's
It's
really
pushing the envelope. Actually, it's a Christmas card.
Oh,
They're not playing it on some station someplace.
Yeah, you should talk about that next week.
Well, next week maybe we'll talk about the other amendments.
Yeah, let's get into some of those because I like to know what all of them are. I mean, I didn't even know there's 26 of them or 25, whatever that is.
One of them I think was repealed.
Oh yeah.
I'm not sure. I kind of vaguely remember that. I'm not really familiar with the ones after 14 up to until the 20.
Well,
one was the right of women to vote.
Oh, that's right. Well, talk about that. See, there are some important ones, you know.
That was one. There are others of subjects that we take for granted today because we've only lived using what the Constitution provides for us.
All right, we got to roll. We got to get out of here. All right,
See you
great
next
show.
week.
Great show.
KCAA Loma Linda, 1050 AM, 106.5 FM, and now 102.3 FM.
Are you a small business owner or pursuing the dream of starting your own company? Do you know where to start or how to grow that existing business? The American Business Trust Company has the answers you need. The American Business Trust Company can help you start up with capital, business strategy, sales, and marketing, and establish your company with a physical location